Now we will start with section 5, Articles of Association. In this in this section, we will see EOA, actually Articles of Association, of the companies Act 2013. Now we will start with section 5, Articles of Association. In this section, we will see EOA, actually Articles of Association of a company contains internal rules and regulations of the company. It is a complementary to MOA and together you depict as a charter of the company. Article established a contract between the company and the members and between the members the same. This contract governs the ordinary rights and obligations incidental to membership in the company. Section 5 of the Companies Act 2013 and Rule 10 and Rule 11 of the Companies Incorporation Rules 2014 seeks to provide the contents and model of articles of association. The provisions are stated below. First one, contents and matters to be included in articles of association. Subsection 1 and subsection 2 of section 5. The articles of a company shall contain the regulation for management of the company and such matters as may be prescribed in Rules 11 of the Companies Incorporation Rules 2014 refer to the matters specified in the model forms given under Schedule 1 to the Act. However, a company may also include such additional matters in its articles as may be considered necessary for its management. So basically, Article of Association contains internal rules and regulation, which helps to regulate the management and it helps management to have some internal rules and regulation which will help the management to regulate the company in order to have and it also includes such matters as may be prescribed in Rules 11, where we have got in the Schedule 1 of the Act, Companies Act 2013, there is a tables for AOA for different companies, which you can see over here. If it is the company limited by share, then company limited by guarantee, and company limited by unlimited company. Limited by guarantee and unlimited company are further divided into companies not having share capital and having share capital, not having share capital and having share capital. And there's tables for EOA. Yep, those are F, G, H, I, J. And for MOA, A, B, C, D. These are the model forms, model formats of MOA, AOA, which have been present in the Schedule 1 of the Companies Act 2013. And there are Rules 11 of the Companies Act, which talks about the matters which should be incorporated into the AOA of the company of a company. Now, however, company has may include such company may also include such additional matters in its articles as may be considered necessary for its management. Now, company can add the provision for entrenchment, which have been mentioned in the subsection 3 to sections 5 of Companies Act 2013. That entrenchment is the chronic or deep-rooted fact of an attitude, habit, and belief. Attitude, habit, and belief that is firmly established or accustomed. Therefore, it becomes difficult or unlikely to change. To illustrate, men don't cry. Men don't cry. Entrenchment may be possible for processes as well as procedures in both ways. That processes are so well established, then it becomes difficult to change them and make process of change so rigid that the process become well established. And here we are learning the concept of entrenchment with the sense of making the process of alteration in the articles more difficult in order to enhance the protection. Usually, an article of association may be altered by passing special resolution, but entrenchment make it more difficult to change the articles in the manner specified ahead. Article may contain provisions for entrenchment, subsection 3. The articles may provide that specified provisions contained in it may be altered only if conditions that are more restrictive and harder than those applicable in the case of special resolution are met or complied with. The manner of inclusion of the entrenchment provision, subsection 4. Subsection 4 of section 4 of Proposed Act says that to include the attachment provision, mm, this can be made only either on the permission of the company or by an amendment in the articles agreed to by all the members of the company in case of private company and by special resolution in the case of a public company. So the timing of entrenchment inclusion is either at the permission of the company or after came into existence. Then in case of private company, there should be the or it should be approved by all members of the private company. In case of public company, there must be a special resolution passed by the company. Okay, now notice to the registrar of the entrenchment provision subsection. Are you read with Rule 10 of the Companies Incorporation Rule 14? The company shall give notice to the registrar of entrenchment provision included in article in Spice Plus simplified program for incorporating the company electronically plus INC 32 along with the fee as provided in the company's registration offices and fees rules 2014 at the time of incorporation of the company. And in case of existing company in the form number MGT 14 within 30 days from the date of endorsement of the articles along with the fees as provided in the company's registration offices and fees rules 2014. Summary of Section 5, 5 subsection 5 and Rule 10 that notice of enrichment add the permission in the form as ICE plus INC 32 or after came into existence in the farm number MGT 14 within 30 days after the inclusion of after the date of enrichment of the articles. Now, model forms of articles subsection 6 to 8 as we have already seen this part here. I mentioned which model forms used for AOA. Okay, now still we have a read. Like we say subsection 5 in subsection 6 provide that the article of a company shall be shall be in respective forms specified in table C of G, H, I, J in schedule 1 of the act as specified in figures. Such forms are called model forms. Further, subsection 7 provides leeway to company in adopting all or any of the regulation containing the model article applicable to such company. Forms of AOA, Table F, Articles of Association of a company limited by shares. Table G, Articles of Association of a company limited by guarantee and having share capital. H, Article of Association of a company limited by guarantee and not having share capital. Table I, Articles of Association of a company of an unlimited company having share capital. And Table J, Articles of Association of a limited company not having share capital. Now, students are advised to take note the subsection 8 provides in the case of company which is registered after the commencement of this act, insofar as the registered articles of such company do not exclude or modify the regulation contained in the model articles of application to such company. Those regulations shall, so far as applicable to the regulation of that company in the same manner and to the extent as if they were contained in the duly registered articles of the company. Either exclude or modify expressly or else it applies what stated in the model applicable to the company. Subsection 9 restrict the scope of section or to the articles either registered or amended under this act. Hence, no provision of this section, Section 5, shall be applicable to the articles registered under the previous company law and provided not amended under this Act. Now we will have some question and answer session. Session in this session, we will see question highlight difference between YAML and EO. Now we will see what is the difference between YAML and EO. The key difference between YAML and EO include first content. So we have seen in the YAML there are different clauses in the YAML. Those are name clause, situation clause, liability clause, then in capital clause, subscription clause, and then nomination clause. So YAML has this content at the same time. EOA has some internal rules and regulation, and that we are interested in the important provision that we have seen in the EOA. But the memorandum contains the fundamental condition as the basis of incorporation. So, memorandum contains is the fundamental conditions as a basis for incorporation. It lays down the parameters that define the relation of a company with outsider. It highlights the relationship of company with the outsiders, where the articles contain internal rules and regulation of the company and hence regulate the relationship between the company and the members and member inter se relationship between the company and members inter se. So when we talk about content, the memorandum contains the fundamental condition as the basis of the incorporation. It lays down the parameters that define the relationship between company and outsider, whereas AOA it lays down the relationship between members of the company and members inter se. Okay, now supremacy. If we talk about supremacy, act is superior, then MOA, and then AOA. Memorandum cannot include any clause that is contrary to the provisions of the law. The memorandum cannot include any clause that is contrary to the law. So the act is superintendent over here, where the article shall not subordinate to both the law and memorandum. Therefore, in case of conflict among the two, MOA shall prevail. Okay. Now, scope. Memorandum lays down the scope beyond which the activities of the company cannot go. An act done by a company beyond the scope of the memorandum are ultra vires and void. They cannot be ratified even by all the shareholders. Articles provide for regulation inside the scope of established by MOA. Hence, acts beyond the articles can be rectified by the shareholders provided the relevant provisions are not beyond the memorandum. Now, here we will see two important things and trends. First one is doctrine of constructive notice and doctrine of indoor management. Both doctrines carries the counter effect to each other. Doctrine of constructive notice puts onus on outsider to be aware of what is stated in MOA and AOA, whereas doctrine of indoor management protects us outsider from internal irregularities. Doctrine of constructive notice. Essence of doctrine of constructive notice is all those who are dealing with the company deemed to be aware of what is stated in its MOA and AOA, as this is a public documents which are registered by the company with ROC in its true perspective, because both these documents are public documents. So these are the public documents. So the matters contained should and the all those who are dealing with the company should be deemed to be aware of the what is stated in YAML and AOA, as those are the public documents. Section 399 provides that memorandum and articles, when registered with the register of companies, become the public documents, and then they can be inspected by anyone by electronic means on the payment of the prescribed fee. Further, Section 17 provides that the company shall, on payment of prescribed fee, send a copy of each of the following documents to a manner within 7 days of the request being made by him. Memorandum, articles, and every agreement or every resolution referred to in subsection 1 of Section 117, if and so far as they have not been embodied in the memorandum and articles. Any failure will make, so here time within 7 days. whether it destroys the company shall on the payment of fees by fees in the copy open. According to him, to a member, to whom? To a member. This okay, so memorandum, articles of association, an agreement which as so far as if and so far as they have not been embodied in the MOU. Okay, now any failure will make the company as well as every officer in default liable to fine of 1,000 rupees for each day during which default continues and 1 lakh rupees whichever is less. So 1,000 rupees for each day and default during which the default is continued and 1 lakh rupees whichever is less. Section 399 is not part of our syllabus but essential to develop understanding. Initiation of doctrine of constructive notice. The enunciation, the doctrine of constructive notice is based on the rule laid down in Ernest versus Nicholas. Ernest versus Nicholas. It was held for the first time that any person who is dealing with the company is deemed to be familiar with or aware of the contents of all the public documents of the company. These public documents are MOU, and the memorandum and articles of association of every company are registered with the ROC, and the office of the registrar is a public office. Hence, the MOU and AOA become public documents. It is therefore the duty of the person dealing with the company to inspect its public documents and make sure that his contract is in conformity with their provisions, as observed by Lord Hatherley, whether a person actually reads them or not, he is to be in the same position as if he had read them. Okay. Effect of doctrine of constructive notice. Every person dealing with company shall be presumed to know the contents of the documents and understood them in their true perspective. Absence of notice. No, absence of notice of MOU cannot be an excuse to claim relief for outsiders, even if the party dealing with the company does not have actual notice of the contents of this document. It is presumed that he has an implied or constructive notice of them. One of the articles of a modern furniture limited provides that a check below rupees 1 lakh may be signed by a single director, but if above rupees 1 lakh shall be signed by at least two directors. Similar instruction is to bank with which the Modern Furniture Limited have account as well. Messrs. Sagwan Woodworks, a vendor, accept a check of rupees 2.2 lakh signed only by a single director. Considering doctrine of constructive notice, the Messrs. Sagwan Woodworks say has no right to claim hence check will be returned without the payment by bank. Criticism of doctrine of constructive notice. The doctrine of constructive notice is an unreal doctrine. People know a company through its officers and not through its documents. Since it does not take notice of the realities of business life, and cause inconvenient for business transaction. To illustrate, where the director or other officer of the company were empowered under the articles to exercise certain powers subject only to a certain prior approvals or sanction of the shareholder, it is difficult for an outsider to ascertain whether the necessary sanction and approvals have been obtained before a certain officer exercises his power or not. 21. Here, absence of notice of MOA cannot be an excuse to claim the relief for outsider. It is mentioned in this case, Kotla Venkateswamy Chinta Ramamurthy. Kotla Venkateswamy Chinta Ramamurthy Madras High. Okay. Therefore, to mitigate such a situation, those dealing with the company can assume that if the directors or other officers are entering into those transactions, they would have obtained the necessary sanction. This is known as doctrine of indoor management or Tulpan's rules, and Turkan's rules and act as an exception to the constructive notice. The Europe Committees Act 1972 has abrogated this doctrine through effect of its Section 9. Even in India, also, the Kolkata High Court enforced a security which was not signed in accordance with the company's articles. This is Charnock Collieries Company Limited versus Bholanath Dhar. Okay, now here, doctrine of indoor management. Now we'll see doctrine of indoor management, essence of doctrine of indoor management. The people who are dealing with the company are entitled to presume that the internal proceedings and requirements has been duly met. The people who are dealing with the company are entitled to presume that the internal proceeding and requirements have been duly met. Enunciation of doctrine of indoor management. The doctrine of indoor management was first laid down in the case of Royal British Bank versus Tulcon. The directors of the company were authorized by the articles to borrow on funds such sums of money as should from time to time, by a resolution of the company in general meeting, be authorized to be borrowed. The directors gave a bond to Turcons without the authority of any such resolution. The question arose whether the company was liable on the bond. Hell, the company was liable on the bond, as Turcons was entitled to assume that the resolution of the company and in general meeting had been passed. Rationale of the doctrine of indoor management. What happens internally in a company is not a matter of public knowledge. An outsider can only presume the intention of the company, but not know the information he or she is not privy to. If not for the doctrine, the company could escape creditors by denying the authority of officials to act on its behalf. Exception to doctrine of indoor management. Relief on the ground of indoor management cannot be claimed by an outsider dealing with the company in the following circumstance. Knowledge of irregularity. In case of this outsider has an actual knowledge of the irregularity within the company, then the benefit under the rule of indoor management would no longer be available. In fact, he or she may well be considered part of the irregularity. Negligence. If with a minimum of effort, the irregularities within a company could be discovered, then the benefit of the rule of indoor management would not apply. The protection of this rule is also not available here. The circumstances surrounding the contract are so suspicious as to invite inquiry, and the outsider dealing with the company does not make proper inquiry. So if you have make negligence in making proper inquiry, or with a minimum of effort, the irregularities into the within a company could be discovered, and the benefit of the rule of indoor management would not be applied in that case. Forgery. Some college having knowledge of irregularity and negligence. In forgery, the rule does not apply where a person relies upon a document that turns out to be forged. Since nothing can be validated forgery, a company can never be held bound for the forgeries committed by its officers. Where the question is in regard to the very existence of an agency. So existence of agency. Because if he is not a director of the company and he's making the transactions, then the question is in regard to the very existence of an agency only, where a precondition is required to be fulfilled before company itself can exercise a particular power. In other words, where precondition is required to be fulfilled before company itself can exercise a particular power. In other words, the act done is not merely ultra-vires the director officer, but ultra-vires the company itself, then it's ultra-vire. So mm, we can have, we can, we can my, it's like, mm, Akshay Kumar Pan, AK Pan. Okay, AK Pan. So A for Now, where a question is in regard to very existence of agency, then knowledge of irregularity. If you have the knowledge of irregularity, then there is a negligence, and you for the precondition is required to be fulfilled before the company can be exercised in a particular power. In other words, the act is not merely ultra vast the directors of the or officer, but ultra vast to the companies. This is for ultra vast and for forgery. Okay. Now, the doctrine of the individual management is considered to be the doctrine of the constructive notice. So it is exception to the doctrine of constructive notice. Now, I will see section 6 in our next video.